Our next program is called M&A Meat and Potatoes. The two panelists are Robert Hensley and John Marsalek, partners in our corporate practice group here at Dorsey, both of whom have a lot of experience in the M&A space, and Robert in particular devotes a significant part of his practice to the construction industry.
Morning, everyone. I'm Robert Hensley, and as Jocelyn said, I am a partner here at Dorsey. I spent 18 years in this office of Dorsey and the last 2 years in the Denver office of Dorsey, moving back and forth between the two. I am a partner in our M&A, merger and acquisition group, and I right now spend more than 50% of my time on construction work, both doing M&A in the construction sector and construction contracts and development type of work. So, to my left is John Marsalek.
Good morning, everyone. I'm John Marsalek. I'm in the corporate group. I probably don't devote 50% of my time to construction work, but I do some work with one of our mining clients and some EPCM contracts and mergers and acquisitions with them.
So we have a little different format than Tim's presentation, which I thought was great and a really good overview to the industry. We are going to get into the much more of the details, the nuts and bolts of structuring an M&A deal, and we're going to start fairly basic and then ratchet up as we go through our discussion. And the first part that I'm going to touch on is business brokers and the use of business brokers in an M&A transaction. From my standpoint, I think it can be something that's extremely helpful, and it's, I think, good to talk about. There's different types of business brokers that are out there. There are investment bankers, as Tim is, who are highly sophisticated business brokers in that category, I'd say, but they are the highly sophisticated members of that group. Probably the most professional, offer the widest range of services, and generally work with medium to larger size companies. And on the other side of the spectrum, you have business brokers, and there are a few local, Coldwell Banker does business brokering of selling businesses, Calhoun Companies, there are others here locally in Minneapolis, and there's various ones. They tend to be more local or regional in nature, but not always. And they tend to be, in my mind, a little bit more on, like a real estate agent with a little more services, but will help you in listing your business, but not as involved and integrated into helping you in the process as an investment banker might be. Just in general, there are benefits to hiring a professional to help you. They can help you market the business. They can help you evaluate your business, just as Tim was going over. I mean, that vast amount of experience on what companies are worth and how you value it. If you're looking to buy a company, things that they might have on their financial statements or in their business that might reduce or increase value over time to you. They could bring you a broader range of buyers. So you may not have access to all of those buyers that are out there, and you might potentially get a higher price. And they can help negotiate some of those more difficult terms for you. There are fees associated with investment bankers, business brokers, and sometimes because there is a third party involved that's helping you, it may not be quite as confidential, and that's always a hurdle I have to get over with people. And they say, I don't want anybody to know about this. I'm like, well, you have to tell people you want to sell your business. That's how you're going to get people interested. So that's always that hurdle. And one other consideration is you might already know the buyer, and it does happen. You hire a business broker or investment banker, and it ends up selling to somebody you knew anyway, and you pay a fee to do that, and it's somebody that you already knew, and that does happen from time to time. But I think in general, people will tell you that they can introduce you to a wider range of circles. So there are both benefits and some other considerations to take in mind when you're doing that. I'd say generally the smaller the company, the less likelihood there is that you're going to hire some type of business broker. The next thing I want to touch on fairly quickly is non-disclosure agreements. And it's when you start to look at a business, either as a buyer or a seller, usually the seller will say, I want some type of non-disclosure agreement. And I will send a non-disclosure agreement to a client or a potential client and say, this is my form. It's a fairly simple 3-page form. It's fairly standard. I usually don't have many people mark it up very extensively, but the purpose of that confidentiality agreement is to protect both parties. If you're the seller, if you're allowing buyers or pools of potential buyers access to your information, you don't want it to become public. So you sign a written non-disclosure agreement just protecting your information. And I tell people to, especially if you're on the buyer side, to try to keep it fairly narrow, because you want to be careful that you're not prevented from expanding your own business because a seller says you misused my confidential information. So you want to state the purpose and be fairly specific about material to be protected. One of the things that often gets negotiated in the agreements is the term of the agreement. So if you have a non-disclosure agreement, I've seen anything from 6 months to forever. Forever is a really long time for a term in any type of an agreement. But inserting a term of how long the information is going to be confidential is important, because not all information becomes stale. The other thing I've seen much more recently in confidentiality agreements, and I put them in virtually all of my agreements now, is a period during which disclosures will be made. And I've seen this become an issue in an M&A context. So there's the term. So if I give you my confidential information as a seller, you're going to keep it confidential, say, for 10 years and treat it as confidential for 10 years. And generally, after that period of time, that information is stale. The other side of that is a term during which you're going to, as a seller, that I'm going to give you confidential information. So I write a term in there that's saying that I will be giving you confidential information over the next 6 months or 12 months, and after that, there is no longer any confidential information I'm going to be giving you. And a situation where I've seen that come up is a company where the buyer and seller were talking. Nothing happened in the transaction. 2 years later, the seller sends the buyer an email saying, oh, by the way, here's some more information about my company. Treat this as confidential under the confidentiality agreement that we signed 3 years ago. And the potential buyer had already moved on, and they were concerned about, well, now they gave me confidential information. I don't even want that confidential information anymore. So I think inserting some type of a term in the agreement deals with that situation.
Thanks, Robert. So I'm going to try to disprove this cartoon and give you a sense of some of the basic structures. There are really 3 of them, but there are, of course, multiple variations. And if you had, for instance, a private equity firm involved, there would be a variation or 2 involved. But the 3 basic transaction structures that people consider are really the asset purchase, where you're purchasing identified assets and identified liabilities; stock purchase, where you're really buying the stock or the equity from the owners of the business; and a merger, where one company merges into, or it could be more than one, but it's usually one company merging into another company, and with one of the 2 surviving and carrying on business following closing. What do you think about? Well, there's a variety of factors. Tax considerations, not surprisingly, is one of the primary considerations. We're not going to talk about that in this session. I think there's one after this that'll address that at least a little bit. Assumption of liabilities is a big consideration. The scope of the acquisition: are you buying an entire company? Are you just buying a line of business? Is it really an assumption of a key contract that you want? Knowing why, and I think Tim alluded to this a little bit in his presentation, really knowing why you're going to do this deal is critical here. Assignment and third-party issues: extent you have permits and licenses and contracts, and you need that assigned to the buying entity, is a big factor. If you're dealing with public companies, and I know Tim dealt or addressed that a little bit, I'm not going to talk about it here, but if you're talking about a public company acquisition, then that will drive you to a merger structure. If it's a negotiated transaction or hostile, same thing, drives you towards a merger. Shareholder consents and accounting treatment. So we'll talk about really 3 of these, and we'll go through the 3 structures just quickly for you to get a sense of what they are and some of the issues. This is the legend. You have it in your materials. Hopefully that will help make some sense out of these slides. What you have on the left is really, and this is a sale of assets, so you've got the TH or the target shareholders, you got the target, you got the buyer on the other side, buyer shareholders. And if you're doing an asset transaction, you're really just talking about transferring the asset from the target directly to the buyer pays the money, and nothing really happens at the shareholder level. And then on the other side of the slide, you can see post-closing. Now the buyer owns the facility or the asset, whatever is being transferred, and the target has the money. Really the key thing here, I think, is that as a buyer, this tends to be very favorable to you because you're only buying the specific asset that you want, and you are only assuming the specific liabilities that you're willing to take on. And so it's great from a buyer's point of view if there's just a particular facility you want, there's a particular contract you want, something pretty specific that you can just take out of the target and you can use. This is great for you. Not as great for the target because what it's left with are the remaining liabilities, to the extent there are any. But if it's a project and there's some warranty claim, there's issues there, environmental issues, that all stays at the target unless the buyer specifically assumes it. So going through our factors, transfer of liability we talked about, third-party consents, because you're not getting anything from the target that's not specifically enumerated. If you are taking on a contract, it's very likely that contract, in the back of that contract, the part that nobody reads, will have an anti-assignment clause saying that you can't assign this without my written consent. And so you need to go out to that third party and get their consent. There tends to be an issue in asset deals if there are, of course, many contracts, then there may be many consents that are required. Stockholders' approval will all depend on whether you're really selling all or substantially all of the assets, and it'll depend a lot on what your charter says. The second transaction structure is a stock purchase. And here, unlike the asset purchase where you're really dealing with the two entities, the target and the buyer, here you're really dealing with the target shareholders and nothing's much is going on at the target company level. The buyer basically hands over the cash, the target shareholders hand over the stock certificates or units or whatever evidences its ownership, and the post-closing structure shows the buyer now is the shareholder of the target and the target shareholders hold the money. And you could, of course, instead of money in these slides, use buyer shares or other forms of consideration, but just for simplicity's sake, we'll just talk about money. Now here, of course, one of the big differences is that by taking on the target and owning the target, you take on all of its assets, but of course you take on all of its liabilities, including any unknown liabilities, things that may be lurking out there that have not come to the forefront yet. Perhaps some environmental issues, some project warranty issues, anything that's out there that the target doesn't even necessarily know, that's now yours. Third-party consents, on the other hand, tends to be not as much of an issue because, of course, the target stays whole and all the contracts that are in the target stay in there, and you're not moving those contracts out of that entity into another. And so the only time that becomes an issue is if the clause, and it sometimes is worded this way, where it says something to the effect of an assignment will include a change of control of the target entity. And so you need to read those carefully, and that's, of course, tends to be one of our jobs as the lawyers reading through those contracts to make sure that you're not tripped up by that clause. With stockholders' approval, of course, you need that here because you're actually contracting directly with the sellers, i.e. the stockholders, and so you really need all of those stockholders to sign on to the purchase and sale agreement agreeing to sell their ownership stake. This becomes challenging, of course, if you have many stockholders, right? So this works well if you've got 5, maybe 10, maybe you could even line up 20 people to sign. But at some point, you're going to reach an upper limit where it's just not practical anymore. In which case, you might look at the merger structure. And here, as I said earlier, you're really merging two entities into one. One's the surviving. There's a few variations of it. A direct merger is really where the buyer and the target merge directly. Nobody likes to do that because the buyer does not want to expose its assets to the target's liabilities, particularly those unknown liabilities. And so this is the direct merger, and you can see, again, the buyer moving the money over to the target shareholders, the shareholders moving their certificates over to the buyer, and they're really just canceled. And now the target T merges into and becomes B. But again, that exposes the buyer's assets to the target's liability, so no one really does that if they can help it. And so what they do is a little bit more complicated variation, but really the only change here is the buyer forms a newly wholly owned subsidiary that has no assets or liabilities and uses that to merge with the target. If the new subsidiary survives, it's called a forward triangular merger. If the target survives, it's called a reverse triangular merger, and this is the one that is virtually always used. And the reason is you get the advantages of the stock purchase, in that the target stays whole. You can avoid a lot of the assignment issues unless, again, you need a change of control consent. So you avoid a lot of those issues. You avoid needing all of the stockholder signatures. You can usually do a merger with approximately 2/3. It varies depending on the state. And so you can avoid getting all the stockholder signatures as well. The liabilities, though, again, you're stuck with the liabilities of the target entity. However, you have shielded them from the buyer's assets by having that subsidiary and having it really end up below your buying entity. So you can see the end result with stockholders, buyer, target, and you're at least shielding the buyer assets from the target liabilities. So hopefully that gives you a not too quick of a rundown, but a rundown of what the basic transaction structures and some of the advantages of each.
So I want to talk briefly about term sheets, letters of intent, and due diligence. And from a transaction standpoint, I generally view there's 3 steps in an M&A transaction. It's a term sheet, step 1, a letter of intent, step 2, and a purchase agreement, step 3. You don't always know you're going through those steps, and sometimes you can meld a couple of those steps together and think there's only 2, and sometimes people will jump all the way to step 3, which is the purchase agreement, and just say we just want to go right to the agreement, and I generally tell people that's almost always a mistake from a time standpoint and a negotiation standpoint. So the term sheet, letter of intent, again, I said earlier, my form non-disclosure agreement's about 3 pages, sometimes 4 pages. My form letter of intent that I start with is 4 pages and usually ends up at 5 or 6 pages. It is generally a non-binding document. There are often a few provisions or a few paragraphs that are binding, but is generally a non-binding document. And here's what I generally tell clients is, bring me a term sheet. And that term sheet can be 1 page, preferably no more than 2. It can be on the back of a napkin with a private company transaction. I really don't care. But bring me something in writing that has the terms that you're thinking about buying this business with before I start drafting anything beyond that. And I can help with a term sheet and give someone a term sheet that is more specific and has blanks to fill in and has quite a bit of information. But if you just start to draft a letter of intent, or even worse, a purchase agreement based upon discussions that you have or thoughts that you might have about selling or buying a business, it gets really complicated because I end up having to tell people you need to go back and negotiate some of these specific terms. So from my standpoint, having a term sheet is very important, and having a letter of intent is a very important part of that process also. You get to agree to some of the fundamental points of the deal and talk about the details of the transaction, and can bring it to a point where you don't end up having to negotiate a purchase agreement at such a long period of time. I've listed here on the slide some of the common terms that are generally in a letter of intent, so that those are negotiated up front in a relatively easy format before the drafting begins. The due diligence part of that is generally what follows a term sheet or a letter of intent. So you've signed the non-disclosure agreement, you've had a general idea now of how you want to buy or sell this business, and then you begin the factual investigation in more detail. Oftentimes you've signed an NDA and you've done some investigation into the business, but not a great deal of in-depth investigation into the company. So due diligence here means the letter of intent has usually been signed. It provides that you're looking at buying a business perhaps for a range of money or selling the business for a range of money, but it's subject to the results of due diligence. And due diligence is there to help you identify risks. Oftentimes it can alter the price, but the goal is generally to confirm the price that you're thinking of paying for a business or selling a business for. The scope of it depends on the complexity of the transaction. I've seen due diligence checklists that are 50 pages long that go into all areas: real estate, environmental, very detailed subject areas, accounting, finance. It also involves going and meeting with people and talking to people, and assessing contracts, as John was talking about earlier. Is there a no assignment clause? Is there a no change of control clause? Do you need the consent of key subcontractors, vendors, and things of that sort? So it is a very, very important part of the transaction. Oftentimes the use of outside accounting firms, legal is important. You may need other specialties to help you look into it. From our standpoint, we often provide written due diligence reports back to clients saying, we've looked at these contracts, here's what we found, here are the risks, or we haven't found any risks in addition to that. But it is very useful to be able to go through that process and help you evaluate the business. And oftentimes sellers are reluctant, especially if they're not this is the first time they've ever sold a business. They don't realize somebody's going to come in and just tear the place apart and look through every piece of information, look for flaws, and really try to understand the business in detail. And it can be invasive. Your employees generally find out about it at that time if you're the seller, because who are these people coming in and talking to everybody? But that's just part of the process. And if you're dealing with a seller who hasn't sold a business before, you just have to get them over the hurdle that if I'm going to buy this company, I really need to do this work.
And it's really important, I think, just on that diligence point, is where we really partner with you, because going back to that comment about knowing why you're doing the transaction, that helps you focus on what to look at. It's hard to see everything in diligence on the target, and you have limited time, limited resources, and in that conversation between us and realizing, all right, this is the critical piece, or these are the three things that we're really after in this deal, it can help focus everyone's attention and spending, that sort of 80-20 rule, right, where you just focus 80% of your time on the things that really matter, and then perhaps a little less on some of the other things, because it's really hard to do a deep dive on everything.
So the next part, what John's going to talk about next, is we're working through this progression where you have a non-disclosure agreement, you kick in the tires of a company, or you're looking at selling your company, a term sheet, a letter of intent, and you're ultimately working toward a purchase agreement, 30 to 60 page long document, sometimes longer, but you're working toward a purchase agreement which has all the details of the transaction in it.
Yeah, and just to, I guess, pile on to Robert's point, I mean, if you don't do that term sheet, and you just say, oh, Robert, I need a purchase agreement, and he's like, well, I don't know, is that an asset, stock? And he spends his time, preparing a 30, 40, 50-page work of art, undoubtedly. But if it's not the structure you go with, changing that over is not a one-hour job. And so you're going to waste time and money doing that, and that will be frustrating to really everybody involved. The key terms, we just thought we'd run through what this thing looks like. The ones that are in red are really the ones we'll talk a little bit more in depth about. Identity of the parties, you can probably guess what that is, define terms. So really, the purchase agreement will be divided into a variety of articles and sections. We'll have one of the fundamental things, again, is the structure, form of transaction. that we talked about earlier that hopefully is also one of the items addressed in your term sheet, letter of intent. Then we'll talk about the purchase price and payment method, reps and warranties, and I said the other items in red we'll touch upon. So the structure we addressed, this section or article of the agreement will follow really the structure of the transaction. If it's an asset deal, all right, what are the assets being bought? What are the liabilities being assumed? If it's a stock deal, what are the acquired securities being purchased? Purchase price, not surprisingly, you're putting in the amount of money. Of course, it could be shares, it could be debt, but we're just going for cash for simplicity's sake. But here, and this was some of the items that Robert addressed in the letter of intent term sheet stage, you might also talk about adjustments. Frequently, you have a working capital adjustment, right? You want a base level of working capital delivered with the company. You don't want it stripped all out. And so you'll specify a target that the seller should be shooting for to deliver. Is some money being set aside as security for any indemnification obligations? Is there a contingent payment? Sometimes you have a big project, and if that's successfully completed, the seller would get some portion of that, or maybe you had a difficulty arriving at valuation, and so you've got some money up front, and then you got some money payable over the next 2-3 years. I think it's fair to say, and Robert, you can comment, those things rarely work out well for the seller. If you're on the selling side, I would tell you do your best just to get an amount that you can live with up front.
Yeah, but if you're a buyer, you want an escrow just in case some reps and warranties or claims come up. So those are the competing give and take, and there are some standards, and John can talk about what you see as the norm.
We'll touch on that a little bit in a bit here. The next section is it tends to be 50% of the purchase agreement, and that's the reps and warranties, and those are really statements of fact about the business that you're buying. And this really dovetails to the diligence that Robert talked about earlier. So you've done this deep dive investigation into the target, and now you're asking the target to make statements about the business, statements of fact. These are all the permits that we have in place. These are all the contracts we have in place. There are no warranty claims outstanding. There's no litigation outstanding. These representations are coupled with what we call a disclosure schedule or schedule of exceptions, and those list the exceptions to those statements of fact. So there are no warranty claims outstanding except for the ones we've listed here on this schedule of exceptions. Highly, highly critical that you look at that very carefully, and again dovetails with your diligence because you're using that information to confirm what you've seen. If you've only seen 5 warranty claims and there's 10 listed, it's like, whoa, where do these other 5 come from? We need to look at that, and we need to know what are those. You also use reps and warranties really to establish your right to indemnification, which we will get to in a little bit here. And that is really, indemnification is your right to reimbursement for certain losses should some of these statements of fact turn out not to be true. If you find out after closing that something that the target represented as being true is not in fact correct, then you would have a claim for indemnification or reimbursement for the losses that you suffered as a result of those statements not being correct. So there's a claim, warranty claim, and it wasn't disclosed on the disclosure schedule. It pertained to a pre-closing matter, and you say, hey, this is $1 million problem. You didn't tell us about this. We're now going to proceed with an indemnification claim against you, the seller or the target, to reimburse us for that loss. So the representations and warranties and the disclosure schedule that goes with it are really highly important for you and us, again, to partner together to review to make sure we're comfortable with everything that we're seeing there. There are frequently some post-closing covenants, so these are really promises that go forward after closing. Some of the more notable ones we've listed here. Usually a buyer will insist on a non-competition obligation from either the target if it's an asset deal or the sellers, or at least a subset of the sellers. if there's someone that is, that would be really detrimental to take the money they get at closing and then start up a new business doing the same thing the day after, you obviously would like to have them agree to a non-compete. Those things range, anywhere from 3 to 5 years, usually depends a lot on how much money they're really getting and then a little bit of the leverage. Confidentiality, so now you're the buyer, you entered into the confidentiality agreement that Robert mentioned at the outset here, where you're not going to disclose the target information. Well, now you're going to be really the owner of the target, and so you really want to almost flip that, terminate the confidentiality agreement, and now have the sellers keep that information confidential because it's now owned by you. Frequently deal with tax matters. There's always frequently a tax return that needs to be filed, and you divvy up the world essentially on an our watch, your watch basis. So you want the seller to be obligated up to closing, excuse me, and the buyer takes the responsibility after. Releases, employment matters, some of the other things that you would address here. Closing conditions. So these are these really spell out the things that have to be true to obligate the buyer to close the deal. Accuracy of those reps and warranties is one of them. So if it turns out they're not accurate, the buyer might have the opportunity here to walk away from the deal. So not surprisingly, targets, sellers want as few conditions as possible. Buyer generally wants as many as possible. It's still difficult to, we usually walk away. I mean, you really need something bad to happen, but it's certainly possible. Here you have a few examples of, I think, some fairly typical closing conditions. Usually the accuracy of the reps and warranties is the most important, but delivery of key consents and approvals. Again, we've done our diligence. We've looked at all these contracts. Maybe not all of them, but we've identified a subset that these are absolutely critical. We need you to get the consent from the other party to these contracts and deliver that to us at closing. You might have key employee matters. Maybe there's a few key people that you need or want to have sign up employment agreements or a retention agreement or something with you to hopefully ensure they stay on.
Yeah. I mean, a good example of that is I've worked with several engineering companies acquiring other engineering companies, and what you want is the people. So, sometimes you're buying assets and it's hard equipment or things of that sort, and sometimes you're buying people. And if you're buying people, those employment agreements and making sure that they come on board are really, really important. And it's probably the most important asset you're buying when you're buying an engineering firm.
Right. So you want to think long and hard what kind of retention plans or equity plans or whatever it is you have that will hopefully tie them in and keep them around. Sometimes you could even tie in some of the consideration being paid, some of the purchase price to people sticking around for a while. Now we get to that indemnification article that I alluded to earlier. And again, this is where you have the parties agreeing to reimburse each other for certain things. It's, of course, most typical that the seller or the target reimbursing the buyer for things that may have gone wrong. The items covered by an indemnity, again, the most prominent being those a breach of reps and warranties in the purchase agreement, but you could add other things here. A breach of one of those covenants, one of those promises could be another item. You may identify other specific things. So you may have seen in your diligence, a tax audit that's scared you, and you said, we need a specific standalone. This is, if there's any amounts owing for this audit, seller, target, you're going to pay for that. Then really the rest of this article generally is the seller trying to fence in that obligation to reimburse the buyer. And how do they fence it in? Well, they put on time limitations. How long do those reps and warranties survive for? Really, how long do you, the buyer, have to make a claim after closing for a problem?
So if I'm representing the buyer, I don't start out with forever usually because that's not a very reasonable term. But I might start out with 3 years for general and a longer period of time for tax. if you're representing the seller,
It's an as-is deal, Robert.
yeah, it's,
There's- there- you
and
know, there's
somewhere in
no-
between is market, which is 18 months?
18 months is
18
fairly
months.
typical.
We know, and so that's, one of the things you'll find is if you're buying or selling and you have an attorney like John that is in the M&A group and works on M&A deals all the time, there's sort of this understanding of where market is and you get there fairly quickly. In the construction area, oftentimes we'll be working with attorneys on one side or perhaps both that don't really understand what market is in most M&A transactions, and it becomes really complex. You know, trying to explain to another attorney who's not experienced with M&A, hey, these are what the terms you normally negotiate, and here's the time limits and everything else you normally see. They just don't have any experience in that world. And so it is important that you get somebody that understands the area and understands what generally you see as far as terms, conditions, time lengths, dollar amounts, and those types of things. Otherwise, you'll either miss it entirely or you'll be negotiating something you shouldn't be negotiating at all.
Yeah, it's a good point. And again, keeping in mind your diligence that you've done, and it's another area where, you know, we need to partner together so that if there are specific items or if there's a good rationale as to hey, this is why we think this indemnification component, let's say this representation should survive for a longer period of time, because we uncovered in diligence these three things. We're concerned about it. We did not factor it into our valuation that we are paying the purchase price on. And so as a result, we think, you know, we are entitled to a longer indemnification period, or, as we'll touch on now, another way the seller or target tries to fence in its obligations here is to put in a basket or a cap. A basket is essentially like a deductible. You can think of your insurance policy for your cars, and you have a deductible. Your insurance company says, you know, whatever, the first $500, you have to eat that before we need to compensate you. A basket is essentially the same thing. There's all kinds of variations of how you might structure it, but I don't think we need to get into that detail. And the cap is essentially the maximum that the seller target would have to reimburse you for. And again, you know, there are market norms and there's a variety of studies out there and all kinds of information that we're well familiar with. And so we've got a sense of what the market norms are to help you through that process. But of course, again, you know, if you can on a principled basis, or you have some rationale as, look, this piece, this item, this problem should be an exception. Here's why. This is what we've uncovered in diligence, and we think it needs to be an exception. Some of the other items, you know, claims resolution procedures, just who's going to handle a claim if a third party comes in and initiates a lawsuit. Does the buyer handle that? Does the target handle that? You know, you have some other bells and whistles, things like the escrow that Robert mentioned. That's really the money put aside and the security. Is there a question? Yeah.
What has your experience been with rep and warranty insurance coverage?
Yeah, that's a good question. I was going to talk about it, believe it or not. You know, that's become, I mean, as insurance in the construction industry, it's a fundamental way to manage risk, right? And it's becoming that way in M&A transactions. It is far more common, and if you have a private equity firm, if it's a buyer involved, or if it's even on the sell side, it almost always insists on that because, of course, the selling PE firm wants to distribute out the money it receives for selling the company as soon as possible. And it does not want any lingering, long-standing indemnification claims and therefore necessitating holding back some money for a few years. And so it will undoubtedly push you to get, as a buyer, rep and warranty insurance. You know, those policies, I think, have come down in price. They tend to be buy-side policies, so the buyer gets it, and the advantage of buy-side is that it covers seller fraud. Sell-side policies do not. The retention, which is really the same as kind of the deductible, that comes down. The buyer and seller frequently negotiate, you know, who's on the hook for which portion of that. Frequently, the buyer can actually negotiate a longer survival period than it would obtain from the target or seller, and frequently a higher cap. higher maximum. So there are a lot of advantages, and with those premiums coming down and those insurance companies that offer it have gotten far more maybe comfortable, adept at going through the process. They don't tend to hold up the process. The exceptions, those insurance policies, right, which is always the hidden gotchas, so those exceptions, the fine print that no one wants to read, you need to obviously read, but there's fewer and fewer of those exceptions. So it's becoming, bigger and bigger. I don't have any numbers for you in the construction industry per se, to be honest. There are some areas that are a little bit trickier. I know in the healthcare industry, a lot of them are a little bit reluctant to insure like regulatory claims, environmental claims, and sometimes you can even buy a specific policy to cover known environmental issues, which is a little bit different from rep and warranty policies, which really cover unknown issues. A little bit of a long answer, but it's definitely becoming more and more prominent. Termination rights, these are just the rights that let you get out of the deal. Frequently like there's a drop dead date. If the thing lingers on forever, you can get out of it. That's it. I think, the point of a lot of what we're trying to say is obviously the industry expertise is very important, trying to know the issues that you're faced with in your day-to-day jobs, but then you want to partner that with the legal expertise to make sure you're getting the agreement that is tailored to your transaction and protects you as best as possible. Thanks for your time and having us, and if you have any questions,
We have a minute.
we have it. Robert would be happy to answer them.
Thank you, Robert and John. We're going to take a brief break now for about 15 minutes, coffee, networking. There's some rolls and I would like to say some healthy foods out there, but I would be lying. That would be a misrep, I guess. But in any event, we'll come back at 10:30 and for the next program, which is discovering and dealing with the liability issues after you have to trigger the insurance policy that John just mentioned. Thank you.